Okay, thank you very much, Tim. I'm Rebecca Garber. I work for the School District of Janesville as a special ed program support teacher and transition specialist. And this is our last Transition Talks Tuesday. So it's been great having all of you join us for these opportunities. And today we get to hear about supported decision making and guardianship. So a very important consideration for our youth when they are 17 and a half, turning 18. So, like Tim already mentioned, we have Danielle. Looking forward to hearing your personal story. And then Shannon Dewey has been working with assisting families with that task for years. So it'll be great to hear her expertise on once you make the decision, just how do you go about that. So we appreciate that. So I will turn it over. It sounds like Danielle, you first.
Oh, hi there, everybody. My name is Danielle Tolzmann, and I am mom to a young adult at home with special health care needs. And I'm going to look to Tim to kind of give me some prompts here as to you and Rebecca on what you might be looking for from me. For our young adult, we did go the route of supported decision making. Um, to be completely honest, when he was in his teens, we were advised by our support and service coordinator for CLTS, somebody that we certainly respect highly and continue to do so. It around transition planning, it was, well, you're just going to want guardianship. You're just going to want guardianship. And so we thought, okay. And just simply not knowing that there were alternatives to guardianship. Um, Once we learned about some of the alternatives and what it could look like, and we learned more about what guardianship does and frankly doesn't do, for us, supported decision making has been the right call. But like I said, we had to learn more about it first, what it was, and then we started taking steps to be intentional about giving our teen opportunities to make more decisions
Mhm.
for himself around things when it came to school, around things when it came to his health care, even just deciding what to have for dinner that night. Started with the small things, worked our way up to the bigger things, and it's worked well for I think for all of us, um, including a time when I got into trouble for telling him that he is an adult and not letting him be one, which he was right to do to corner me on that.
Do you want to tell that story briefly? Is it a brief story?
Sure. He was maybe 18 and 6 months or so. It was one of those where he needed to be somewhere else, and there was a visit due to review goals with his speech language pathologist. And so his dad and I were like, you know what, buddy, you go ahead and go to work. Mom and dad will handle this for you. Okay, fine. Well, once we got in that appointment, well, surprise, surprise, we changed some of his goals. Yes, and that is the correct response, Tim. He went to his next appointment. He came home, and he was mad, reasonably so. He was mad, and he was like, "You can't tell me I'm an adult and not let me be one." And once I got over this, oh, how can you talk to me like this? I'm like, you know what? He should be talking to me like that because that's exactly what we did. But and I went back to him after and apologized, told him he was right, and that I wasn't going to do that again. And I applauded him for standing up for himself and putting dad and I, frankly, in our rightful place. As uncomfortable as that was for me as
Right.
mom, But yeah, yep.
So, what were some of the thoughts that you had as you were balancing guardianship versus supported decision making? What were some of the things that you were thinking about, if you can remember? I mean, I know it hasn't been that long ago, Danielle,
But it's been a
but
minute.
it's been a minute. I
Yeah,
know.
yeah. Um, I think the big thing for me is that my guy is highly compassionate and could be potentially swayed. I didn't want him to get taken advantage of. Frankly, it was a safety thing. If Sarah McLachlan called him and said, I have all of these hungry puppies, will you please donate? Oh yes, he would be very happy to give everything. But what we didn't realize is that what we could do is he could agree and establish per transaction spending limits on his debit card. So he could still, if Sarah called, make a donation, but it wouldn't empty out his bank account because the transaction would just reject. And that's worked for us. The limit is such that it's enough that he can get his most common groceries, but not so much that if he's, buying $500 worth of steaks, well, on the phone, that's not going to go through. And so knowing that there were other tools that were available to resolve the things that we were worried about and let him make his own decisions about things, ultimately still let him be, air quotes, the decider, that was important to us. That was important to us. But safety and making sure he was protected and wouldn't be taken advantage of was a big thing. For us, I think one of the ways that we were able to get there, frankly, is by having him start deciding things, having him start deciding small things, and have him start deciding things that even didn't go according to plan. I think he learned more from the things that didn't work out that he picked, but that didn't work out the way he thought they would. And he did learn from those things. And when he was faced with the decision again, he would be like, last time when I turned left, this happened. So I don't know that I want to do that again. I'm going to try a different decision and see if there's a different outcome instead. But
I have a question, if you don't mind. You mentioned that initially you had heard, guardianship, and
yeah,
until you learned more
yeah.
about the other options. Can you talk about where you learned about those other options and how you got to a point where you just had enough information to make the best decision?
I can. It was actually through this little program that was available then in the Dells. Is it still going, Tim, in Milwaukee at all? Not at all. It was Yippee. Tim knows the acronym, but it was one of these. I guess I would call it a transition planning workshop series, I think is how I would maybe describe it. But unfortunately, it's not a program. I don't think that is still going.
I'm
Um,
efforting it may be just a little something, but it's no longer statewide, that's for sure.
yeah, yeah,
But yeah, there are I mean it's by attending things like this that we're trying to get the word out about the different options. So yeah, I'm very sad that Yippee is no longer around. Um,
Would you mind telling us a little bit about your son and his what is his level of independence? Does he live with you? Does he work? If you could just share some of those details, that'd be
yeah.
great.
sure.
And then there's also a question in the chat for you, and then I
Oh,
think after that we'll move on to Shannon.
okay. Um, Rebecca, I apologize. I opened up the chat and lost track of your question. Please repeat it.
I was just wondering if you could describe him and his level of independence a little bit.
Sure.
Does he live by himself? Does he work? And things like that.
Yeah. No, that's all right, Tim. And by the way, too, he does know that I'm coming on here to talk about him tonight. So I shared this with his permission. Um, he is affected by a chromosome microdeletion, which looks a lot like autism spectrum disorder and some other comorbid stuff, accompanying stuff. He does still live here at home. He is, I guess you could say, working. He's about to graduate from Project Search. Yeah, yeah, and it's going really well. But yeah, he's he's it's hard for me to quantify his degree of independence because it varies depending on the task. One of the things that's been important for my husband and I in getting him to where he's at, though, with his level of independence, is frankly my husband and I, probably when he was in his mid-teens, we had to be intentional about just not handling everything, not deciding everything for him, and pointing out, we'd go for a healthcare checkup, for example, and it was maybe time for a medication change. And the physician would talk us through, well, this is what I'm thinking. She'd talk through these options, the pros and the cons, or this medication, the pros and the cons. Before I said what I thought, we asked him what he thought. And I can tell you, he's a good decider. He's a good decider. But what it did take is some degree of intentionality for my husband and I to not just handle things, to not just solve things, to not just answer things. Sometimes that meant he was shushing me, and sometimes it was the other way around. But I feel like that was really important to where he's at today. It was also true, and I should share this real quick, that he organically seeks our opinions on things. What we work really hard to do, though, is not share our opinion. Well, I'll kind of lay out the picture of pros and cons, and I work really hard to be as unbiased as I can. Um, but I really make it known that, well, this is really a decision for him. And he's like, well, what do you think, Mom? And I'm like, well, it doesn't really matter what I think. It matters what you think. But here are some pros and cons to think about either way. And he's made good choices. He's made good decisions. So let's see. Are you continuously finding areas you didn't think to apply safety measures? Um, Yes and no, but I think that we have most of those, I would call them speed bumps, worked out. Because when we bump into something, then we'll talk about it. Like, he has a difficult time with reading, especially the fine, tiny print on a lot of, well, contracts, government documents. Please sign here, even when the iris consultant comes over, right? Here's a pen, you need to sign here. Yeah, that thick stack of paper, exactly. He does know that before he signs his name to something, he should ask one question. What is this for? And that is something that we have just started, you know, putting into the routine of writing your name before you write your name, before you sign something. And he does understand what his signature means, that it's a promise, that it's concrete, that even if, you know, that whatever he signs is a promise that can't be broken. And that is something that he does a good job of understanding. Um, but otherwise, Elena, to answer your question, we really haven't. We've been good. He's a good self-advocate. So if he wants a supported decision maker with him, for example, in a healthcare setting, he will say, no, 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 I want them with me in here. Or I want them in here to help me decide this. Or if he needs to decide something, he'll say, nope, I'm not deciding this on my own. But again, we work really hard to not decide for him or to tell him what to decide. We work really hard to keep our opinions out of it, which is sometimes harder than we think, especially with our kids. But I hope that helps.
You actually sound like you're doing a much better job than I am. I am still opinionated with my son, um,
All
because I get so scared. So I
right.
totally understand. So thank you so much,
Yeah.
Danielle. Let's transition over to Shannon. And I'm sorry, Shannon, that I threw you a curveball right off the beginning
You're
here,
fine.
but I appreciate you and I appreciate you being here.
Yeah.
And I'm going to spotlight you. Did you have a PowerPoint to share too?
No, but I am
No?
not as bougie
Wonderful.
as Jamie. I am
Oh,
just
I
gonna
love it.
gonna wing it. So, as Tim said, that my name is Shannon Dewey. I work for Rock County Human Services. So, just to kind of give you a little bit background, is that I've been a social worker for a lot of years. And previous to me being in this position in adult protective services doing guardianships, is that I did work in the children's world. So I've worked for birth to three child protective services, and then I did over 7 years in children's long-term support. So I was already kind of familiar with some of these things that were happening as youth transition. And so when the opportunity came to step into this role, I jumped at it because I really feel that it's important that there's advocates out there for our youth as they're transitioning. One of the things that I do in my position is I also meet with families and talk about all the different options. I don't just jump right into guardianship. I did not as a CLTS worker either. So I will meet with families, talk about supported decision making, talk about powers of attorney, releases of information, all of those things as well, before you jump into guardianship because it is the most restrictive here in the state of Wisconsin. So a little bit about guardianship. So we operate under Chapter 54. So if you have a sleepless night some night and you really want to read, go read through Chapter 54. That is what mandates everything that we do here in the guardianship world. So I'm just going to read the definition of what a guardian of an adult is, because for those that have youth that are transitioning, it is not the same as your just mom, your guardian of your child. At 18, they become their own person. What guardianship of an adult is, it's a legal process where a court appoints a person or an agency to make decisions for an adult who is deemed incapacitated or unable to manage their own personal, health, or financial affairs. So this is not supported decision making. Supported decision making is fairly informal. You sit down, you can have it witnessed, you go through, you have these conversations. This is a court process. As far as what guardians are, there's two different types of guardians that we talk about, and that is you can be a guardian of a person, of a ward. I don't really like that term, but that's what they're called, is wards. Guardian of person really oversees personal decisions such as medical care, housing, nutrition, safety, making sure that their daily needs are met. That is guardian of person. Guardian of estate is what it sounds like. It is about their finances. It is about their property. It's about their income. A lot of our youth that are transitioning don't have estates, but it's still called an estate. It sounds really technical, but it really is just making sure that they're managing their money, their bills are getting paid. One of the things here at Rock County that we have run into, and I don't know if this is the same across the state, is that our families are having bigger issues working with Social Security and the banks not having guardian of estate and only having guardian of person. And so we have made that step over the last couple of years to file for guardian of estate for all of the youth that are transitioning, just so that way they have, the parents or the guardians have an easier time of trying to work on getting those benefits if they don't already have Social Security, SSI. And because we do guardianships from 18 to end of life, there's some people that, in order to do their Medicaid review, they're not able to get very far without having that guardian of a state. So in order to file for guardianship, there's some things that have to happen first. And so the kickoff point for that is you have to have a doctor that is willing to do what's called an examining physician's report. And the form is GN 3130. And I can put form numbers in here, but what I would strongly recommend is just contacting either your local probate because they can help walk through that, or whoever it is that handles guardianships in your county. But the examining physician's report has to be done. Oh, look at you, Tim. I love you. Thank you. So that has to be completed by a doctor. It can be a psychologist or a psychiatrist or a PCP. It has to be done in person. So keep that in mind when you are going to, oh, my youth is turning 17 and a half. That's why we want these referrals at 17 and a half and encourage you working on this, because sometimes it takes a while to get into a doctor, as we all know. It could be a neurologist. Let's say your PCP only sees your child once a year, but your neurologist sees your child every 3 months. They may be the one that's willing to fill out this examining physician's report. It has to be done in person because they have to read the youth their rights. And it sounds scary, but really the conversation should go fairly similar to the reason why you're here is because we're assessing to see if you need a guardian. You have the ability to talk to me. If you choose not to talk to me, then I will look at collateral sources of information, gather whatever I need to do to complete this form. So it'd be better if they talk to them or they engage, but we have had youth that have said, nope, don't want anything to do with this and have walked away. But at least the doctor read them their rights. The very first thing on the examining physician's report says, prior to this evaluation, did I read them their rights? And if that is not marked a yes, that is going to get kicked out of court real quick. So just make sure that you're aware of that. I recommend reading through that examining physician's report so you know what it is that they're looking at. There are trigger points within that form that is what basically recommends whether or not a guardian is needed. So that is the biggest thing, is that examining physician's report. Not only does it help determine if a guardian is needed, but it also looks at protective placement, which is usually used when somebody is in a facility that's 16 or more beds. That is mandated that if they're under guardianship, they have to have a protective placement order. But it's also for those individuals that may really struggle. They're an eloper. So if you were to get them into an adult family home, but they're constantly running away, police have to go find them. With a protective placement order, law enforcement can pick up that person, take them back to their placement. With a protective placement order, the guardian has more ability to place somebody, just not in a mental health facility. So the other thing that needs to be completed by parents is what's called the Statement of Acts, and that's Form GN 3140. Basically, that is for anybody that's either going to be a guardian or a standby. It is, it's basically a declaration of any criminal history that you may have, bankruptcies that you may have filed. If you're on the misconduct registry, that has to be completed. It also shows whether or not you are interested in being the guardian of person and estate or estate. And then if you're going to be standby, it's also used if there's a successor guardian that needs to be found as well. My personal recommendation and what I do with all of the ones that I file here in Rock County is that I really encourage families to have more than one person be guardian. If whether it's co-guardian or there's a standby, because there are situations that happen. It could be that you're on vacation and you are not able to be reached. Somebody needs to be there to be a decision maker. We have had unfortunate situations where the guardian is fairly young, but there's been a horrible accident or something has happened that they're not able to act in that role anymore. So if you have somebody that's already standby, it makes the process go so much easier. So then the third thing that absolutely has to happen is that all people that are looking to be guardian, proposed guardian, whether they're standby or the primary guardian, need to complete what's called the guardian training. This is done through the University of Wisconsin Green Bay. There's a form that you have to fill out, GN 3135, since Tim's having fun finding these forms. It is a free training. It is mandated by the state of Wisconsin, so you can't not do it. And it's free, it's online, but it's a start and stop. So if you're a parent that has, every night from like 9 to 10, that is your time when you have the ability to be able to do things. You can start it. And if you don't finish it, you can go on. You can do it some other night. I would say that the average time to take it is about 3.5 to 4 hours. And it's really good information. And I'm going to go back to Danielle about this as well, is that she had Yippee. What I also encourage families that if they're not sure is to take this training, do this training, because it not only talks about guardianship of person and estate, but it does talk about supported decision making, powers of attorney, all the alternatives to guardianship. And it's a really great training. And I've had families that have come back and said, you know what, we are going to try supported decision making. Or they've come back and said, yeah, I just don't think that's going to work for our family. We are going to go the guardianship route and do that. What I will say in our county is that if you try supported decision making and it really is not working out, there's just a lot of things that are going on. It doesn't mean that you can't go back and revisit and possibly do guardianship. So the other also, just so you know, with our court system, and this will be different with all 72 counties in our state, is that our county understands and our court understands that there's also things that happen with youth from 18 until whenever, depending on their life skills, the trainings that they've gotten, that maybe guardianship at 18 is what was needed, but now at 27, maybe not so much. So it used to be once guardianship, always guardianship. I think that has really shifted gears, which is awesome to be able to see that. It just really is simply having that youth or that young adult be reassessed by a doctor, do the same examining physician's report, and then they can file to then have that guardianship dismissed. So there are alternatives, and we talk about that a lot in this position. So once those things are completed, so generally, if I'm working with a family, and we do assist families if they meet our financial eligibility requirements, is that then I usually require, I do require, I shouldn't say usually, I do require that all of those things are done. And then that's when the petition gets filled out and gets sent over to our corporation counsel, who then processes it and goes over to our probate to get scheduled. So the petition that gets filled out is GN 3100, Tim. So, and there's also interested parties that need to be identified. What I will say is there's some counties, so like I said, with Rock County, we have eligibility and income requirements that if you meet those, we will do all of that legwork for you. The other thing that could happen is that you could file it on your own. I've had many families. I will still come out personally in Rock County and talk to families about this is the process and kind of assist through. So that way they have an idea. Our probate has a wonderful list and steps on how to do this. So I would check with your local probate office to see if they have something as well. So it can be filed on your own. The other thing is that you could have an attorney do it. So depending on where you are in the state, how long it takes, I've heard of low ball, probably about $1,500 to $1,800, and all the way up in excess of, you know, $3,000 to $4,000, depending on, if it ends up being contested, how much time it takes to really get into filing all the paperwork and doing all that. So there are different options on getting this into your court system. So once the petition's filed, once there's doesn't matter which county you're in, once that is filed, the courts have 90 days to make that decision on whether somebody is deemed incompetent and that they need a guardian. So if you guys are starting to get to the point where you're like, we still don't have a hearing, or this is what's going on, you need to really advocate to get this done, because at that end of 90 days, then the courts lose jurisdiction in the matter, and then you have to start all over again. And you don't want to have to do that. You might be able to reuse the examining physician's report, but as far as everything else, it's going to have to all be refiled. So once that all happens, you have a hearing date, then the proposed ward is then assigned what's called a guardian ad litem, a GAL. That GAL is going to be the voice of that person in the court system to say, yes, they are in agreement with the guardianship and or protective placement, depending on what's going on, or they're not. And if they're not, then it's considered contested. And so then at that point, depending on the county, in our county, it goes from our commissioner then to a judge to be heard. And if it's contested, then they'll also be assigned an adversarial counsel. So it does get very technical. That's where you can accrue some costs if you're using an attorney, is through that process. So once the courts do deem somebody that incompetent, so the doctor does the initial incompetence, and then the court does the final one. That's when the rights are reviewed. So there are several rights in there. There's 3 that are either yes, that the ward can keep that right, or no, they can't. That's the right to execute a will, serve on a jury, and understanding and executing, basically being able to vote. In our county, our court commissioner is a huge proponent for people to keep their ability to vote, because once you lose that, that one is really hard to get back. And then there's other rights that are either yes, they can keep that 100%, no, they can't keep that right at all, or with guardian approval. So like consenting to marriage, that could be either yes, they could get married, no, they can't, or with guardian approval. So if there's a guardian approval, then they can't even go get a marriage license without somebody signing that paperwork. What a lot of families see when you're going through the rights is that the one on there that always makes people chuckle is the right to obtain a fishing license. That's because it's a state issued license, so they have to have it on there. Our commissioner always keeps that as a right. That has never been taken away from anybody, just because it's so benign and anybody can go online and get a fishing license. But there's some of those that you can really negotiate and say, I don't feel like my child should be able to, or they don't have the ability to go out and make a decision about getting married, but I also don't want to remove that from them completely. So that should be something that should be talked about. There's also consent to donate organs and tissue and things like that, that most of our courts will look at that and say, do you feel like they would have an understanding to know that if something happened to them, they'd be willing to do this. So our court is very strong in, even if there's a guardian that's been assigned, is you should still be having those conversations with whoever the ward is when you're coming to make those major decisions. They should still have some say in, do they feel like they should, move into an apartment? Can they live on their own? Do they go to an adult family home? If they don't like their doctor, can they change doctors? Those kinds of things really should be something that's continually discussed anyway. So the requirements for follow-up once a guardianship is done is that annually if you are a guardian and you are not the guardian of a state, just the guardian of person, then you have to do an annual report on the condition of the ward. And it's just a simple little form that basically says, this is where they live, this is how things are going. That is a state mandate you have to do every single year. The probate office generally sends that out. So you have that, you send it back, you fill it out, send it back. Guardian of a state, depending on the county, how they want to do this, our commissioner has taken the stance that if they don't have an estate per se, if they're just receiving SSI, they don't have assets, they don't have this huge trust, there is an annual accounting review that needs to be completed. And in our county, if you turn in the inventory within the 60 days when you first become guardian, she's been waiving that because the thought is that Social Security can already audit you at any time, because it is tedious. You have to save all your receipts. You have to keep track of every single penny of income or anything that is spent on your ward, and that has to be then submitted to the court yearly. So it really is one of those that it made more sense when you have somebody that has a huge estate and now suddenly has dementia or something like that. But for a lot of our youth, they don't have huge bank accounts, they don't have huge trust funds. So what a guardian cannot do, because we get this a lot, is that I want my daughter to have a guardian because I am tired of her hanging out with Joey down the street who is a bad influence and they're constantly getting in trouble together. A guardian cannot keep somebody from making friends, who their friends are, their romantic interests, even if they're not a good influence. That's just not something that they can do. They can't keep people from making poor choices. Our whole entire life, we build our life on learning from our mistakes, as Danielle was talking about. You take a left this time and you go, oh, that didn't work out so great. Now we're going to take a right. There still is that potential for learning, and there's still that they're still going to be making poor choices that we sit back, and a lot of us as parents, and go, oh gosh, I don't know if I would have done that. But it's their right to be able to make those poor choices. If they're in a placement and they get so much, spending money per month, a guardian has no say in how they spend that money. And this sounds really harsh, but if they decide they're going to go out and they're going to spend it all on pot or alcohol or games or anything, door dashing. I had one that would spend all of her allotment within 3 days from just door dashing stuff from Quick Trip, which I do love Quick Trip, but that's a lot of money to spend in 3 days from Quick Trip. So you can't force somebody to live somewhere that they do not want to unless they're under protective placement. So, that's where those conversations need to constantly be happening with the ward. What is in the best interest? What is the least restrictive? I know everybody hears that constantly, is least restrictive, and that's what we need to remember through all of this, even if they're under guardianship. So most of our counties, we can't provide legal advice, but there are potentials that there's some law schools that are out there that may be willing to kind of guide you through some of this process. Like I said, some of our local probate offices will actually give you steps and talk you through it where others just won't. The biggest resource that I would say, if you're having questions besides the guardian training, is our GWAR website, and that is GWAAR, and it stands for our Greater Wisconsin Agency on Aging Resources. It's a mouthful. However, they have so much great information on that website. And it's not just about guardianship. There's just a lot of really good information in there, that if you're struggling, they do have an attorney that is on hand that answers questions. They keep up on legislature and things that are constantly changing, not only about guardianship and protective placement, but about powers of attorney, things like that. supported decision making. So I would really strongly recommend taking a look at that. So just a reminder, each county is going to do things differently. So if you really have questions, you're not sure where to turn to, if your children's long-term support worker is not familiar with the different steps, don't be afraid to ask those questions. Contact your local probate office. They could probably give you some directions. Guardian ad litem fees, sometimes the counties will pay for those. Some counties require a deposit. So there's a lot of little pieces that go into this that you're going to want to make sure that you understand how your county then works with the families to get these things done. So once again, guardianship training, if you're just even trying to figure out which direction you want to go, they're great. Legal Action of Wisconsin, we've used them. We've given people that information. You can Google search in your area, law offices that do guardianships. You could get some of the forms completed on your own and then just have an attorney just review them as well. So there's a lot of different options out there, but it's a process. So I want to just really preface that at 17 and a half, if this is what you're thinking about doing, really start digging in and getting this done. I know with our county, and I've heard that we're actually pretty fast compared to some counties, is that once we get everything filed, we're about booking out about 4 to 6 weeks for our hearings. I've heard some counties it can be a year, 2 years, 3 years, which is really sad for me because I think of all the families that are sitting out there waiting. But just advocate for your youth, whatever it is, whether you think that supported decision making is what is going to be best, or going the guardianship route. Just you are your youth's best advocate at this point. So that is what I have, Mr. Markle.
And my fingers are tired. I'm trying to
Sorry.
find all of the forms. So, thank you so much. That was like, if I could have asked you to do what was in my brain of walking through the guardianship process and been able to download that to you, you would have done exactly what you just did.
Thank you.
So
Lots of practice.
I really appreciate that. So what I'm going to do is I'm going to go ahead and thank everybody for being here, but don't go anywhere. Thank you all for being here. I'm going to put the evaluation back in the chat, but I'm going to stop the recording.